We've got some breaking news, and this concerns the Delhi Chief Minister Arvind Kejriwal. His bail plea is currently before the Delhi High Court. Now, the Delhi High Court has issued a notice over the bail plea that's been filed by Arvind Kejriwal, and the High Court has sought a response from the Central Bureau of Investigation over that bail plea, seeking bail in the CBI case that's pertaining to the excise policy. My colleague Ananya is joining us on the broadcast. Ananya, what happens next, considering the response of the CBI has been sought now by the HC?
Well, interestingly, Griha, without approaching the trial court,
Yes.
the Delhi Chief Minister approached the Delhi High Court directly. And now the Central Bureau of Investigation has been asked to file its reply till the July 17th. And, the CBI was constantly opposing this, saying that, it is kind of, not appearing before the trial court. They are skipping that particular remedy and now coming before the High Court. So, all of these contentions would definitely be there in the reply that would be filed by the Central Bureau of Investigation. What would be the final outcome of it, whether or not the Delhi Chief Minister would be able to secure a relief from the Delhi High Court, is something that we'll have to wait and watch for. But at this particular point of time, Arvind Kejriwal constantly alleges that he was illegally arrested in the CBI matter, and proper procedure of Section 41A under the Code of Criminal Procedure, or the CRPC, has not been followed. And he is, this is not a special case where, special provisions like the twin conditions under Section 45 of the Prevention of Money Laundering Act 2002 comes into play. And that's the reason why, they say that this matter should be heard urgently, and, Arvind Kejriwal should be released on bail. However, the Central Bureau of Investigation goes on to say that, there is a charge sheet that is likely to come up against the Delhi Chief Minister. 4 charge sheets have already been filed in this particular matter. And, he's one of the key conspirators in this particular case. In fact, he is one of the key kingpins and the bribe takers, bribe demanders, in fact, wherein he had demanded 100 crore bribe from K. Kavita and, Manguta Srinivasanu Reddy. And hence that's the reason why, he should not be granted bail in this particular case. But what happens next is something that only time can tell us.
Ananya, tell us something about Kejriwal and his counsel, Mr. Manish Singhvi, while they are saying, and they are obviously relying on the fact that Kejriwal is not a proclaimed offender, and that's why probably this confidence of reaching the High Court directly for a bail plea and skipping the trial court remedy?
Well, definitely, they say that he is somebody who has been in the public life. He's not a flight risk, and he's not a terrorist either, is what Dr. Singhvi actually pointed out to the court, and said that, since there are no special provisions also in fact, the CBI case, there is no 45 bar. Hence, approaching the trial court is not the wrong fashion. It is a concurring jurisdiction that can actually be accessed by the Delhi Chief Minister. So, how would things pan out, whether the court would go into this issue of concurring jurisdictions and not, approaching the trial court? Because, the High Court was also, at one point in the beginning of this particular hearing, was of the view that, whenever the High Court actually receives a bail application or any kind of a petition after the benefit of a trial court order, they have the benefit of those observations that the trial court makes, how the trial court deals with that particular law, and then, the High Court would go into as to whether or not these observations and apprehensions are right or not. So, that would not be there. So, we'll have to wait and watch as to how things pan out in the
So, we'll have to see what the response of the CBI will be as far as the High Court is concerned. Let's actually leave it at that. Ananya, thank you so much for